Is this good? Maybe too loud, like this? I hear echo, but maybe it's here. Yeah. Don't you, is it good for you? Okay, there's a kind of an echo here. Even kijken. Not on paper, ESG friendly, the speech, but on the iPad. So, all right, so I think we can start. Is it open? Okay. So, ladies and gentlemen, dear colleagues and friends of EFILA, it is my great pleasure and honor to welcome you to the 8th EFILA lecture here in the Brussels club, in the press club in Brussels. Previous speakers included such illustrious speakers as Sophie Nappert in 2015, followed by the late Johnny Feeder in 2016. In 2017, we had Judge Christopher Greenwood, followed by Professor George Berman. In 2019, we had Professor Laurence Bosson de Chazonnet. In 2020, we had Professor Lucas Mistelis, our former chair of the executive board of EFILA. And last year, we had Annette Magnussen, the climate change lawyer. But this year, as you can see, we have a very special lecture since we will have actually 2 speakers instead of 1. So you get, as I said on LinkedIn, you get 2 for the price of 1. So it is a particular unique experiment that we have here today. And so first, let me introduce the speakers, and then I will say a few words about EFILA. So first we have Gillian Kern, who is a US licensed attorney who focuses on complex environmental and energy litigation, transactions, and compliance. He has spent the past decade as a partner at a large international law firm, regularly consulting clients on the development and implementation of environmental health and safety compliance and ESG programs. She's also currently a sustainability and compliance advisor with the Stockholm-based organization Climate Change Council, which is the organization founded by Annette Magnussen, the speaker of last year. So you can see there is a kind of tradition that we are building with Annette. And you didn't say that when you sent your bio, but I double checked it. You have been named Environmental Lawyer of the Year at Euromoney Women in Business Law Awards Americas in 2021. So I think we should mention that. Second, we have Laurent L'Hospitalier. I know my French is horrible, who oversees Sanofi's ESG efforts, ensuring the integration of ESG in business strategy, in financial instruments, and the equity narrative. He joined Sanofi back in 2013, where he became part of the global corporate social responsibility team. Prior to this, he worked as a consultant at Deloitte, where he led global projects for the design of sustainability strategies in embedding human rights in business processes and in implementing environmental, social, and governance ESG due diligence. He started his career working on land reform in South Africa. So you see, we have 2 distinguished experts who have very extensive experience in ESG. Third, we have Quentin de Clève, who is a senior associate at Van Bael and Bellis here in Brussels, where he specializes in EU law, international dispute resolution, and competition law. He represents clients in arbitration proceedings as well as before the EU courts and Belgian civil and commercial courts. He holds an LLM from Columbia University in New York, which I understand is also the case for Gillian. So, exactly. So we are all in a common ground here. And I should say, very importantly, Van Bael and Bellis is one of, I would say, the most prestigious law firms here in Brussels, which agreed to sponsor this event. Equally, like every year, KKG, the leading Polish law firm and long-term EFILA member. And we are really very, very grateful that we have the sponsors. So I'm really thrilled that you are all here as well as online for this flagship event, which I would like to claim is the key investment law arbitration event in Brussels. Now, before we start, please allow me to say a few words regarding some of the recent developments at EFILA and some upcoming activities. First of all, I would like to mention that since last June, Miriam van der Hel Kudot, who is partner at Nauta de Til law firm in Amsterdam, is the new chairwoman of the executive board of EFILA. Second, we also have José Ángel Rueda, who is partner at Cuatro Casas law firm in Madrid, who has been the new chairman of the advisory board of EFILA and who is here today with us. So we have a new leadership at EFILA, and I'm very much looking forward to develop and expand EFILA further in the coming years. Third, as you can see on the screen, maybe the next slide, please, we will have our next annual conference at Cuatro Casas on 16 March next year in Madrid, with a title that kind of continues the discussion of today: Climate Change and International Investment Law Arbitration, Challenges and Uncertainties. We are working on the program and we hope that we can publish the draft program very soon. So please do check our website regularly and register. Fourth, last June, we have established Young EFILA. And I remember that last time I announced that we would do that, and it has really taken off incredibly. We have more than 50 young EFILA members already. And we had a wonderful kickoff event in June with a Oxford-style debate. And they will also have an event back-to-back to our event on 15 March in Madrid. So do check out the EFILA website. We have a specific tab on Young EFILA. And of course, you should become Young EFILA member, everybody who is under 40. So not for many of us anymore. And Young EFILA also took over the EFILA blog since this summer, and they have made a really a huge makeover with a proper editorial board and the regular blog posts and interviews with arbitrators. So I invite you to send your submissions to the EFILA blog for publication. And speaking of publications, the next issue of my baby, the European Investment Law and Arbitration Review, is currently in print and will be published this December, exactly before Christmas usually. So as in the last years, it will be packed with very interesting high quality articles and case notes covering what has been happening in the last 12 months regarding intra-EU bids, the ECT, and I just read that Spain announced that they would pull out of the ECT. So we are not yet done with all this that's happening right here in this Schumann roundabout. And as a sneak preview, I can tell you that the opening article will be by Pascalidis, who has been one of the referendairs who drafted the opinion of Advocate General Vatele in the Agmea, and who explains in very, very detailed analysis why the European Court got it wrong in Comstroy. So it will be really a very interesting issue. And the call for papers for the next issue is open now. So you can see suggested topics on the website, and the deadline is 1st March. And we also have what we call a Young Practitioners Essay Competition, where you can actually win money in the form of books that you can select from Brill. And you can get also free pass to the EFILA conference. So it's really worth trying to send your submission for the essay competition. Check the website for our details. Now, let me turn to our event of today. So as you all know, ESG is a hot topic everywhere. So of course we couldn't stay behind, right? It's as simple as that, right? So it's not a surprise that ESG was on our list. However, there is a lot of unclarity and uncertainty surrounding ESG, which stands for environment, social, and governance. What is actually falling under these categories? What is their legal status? To what extent are they binding? And on whom? Only on companies/investors, or also on their board members, or maybe also on states? What is the difference with CSR, corporate social responsibility? Is there an overlap between these two, or do we all lump everything together and we have a wonderful alphabetical Greek salad? These were some of the questions that I had when we selected the topic. And so how do we answer those questions and many more? Well, we thought as good lawyers, we first need a legal framework. We need to understand what is the legal framework. And then we thought, okay, that's fine, the legal framework, but we also need to get the perspective from the ground, from the investors, from the companies who are affected directly by the ESG obligations, by the ever expanding, I should say, ESG obligations. So we found Jillian, who enthusiastically agreed to provide us with a legal framework. She will speak first, and subsequently, Laurent will reflect on how ESG considerations are shaping Sanofi's business and financing strategy and its equity story. And then both will react to each other's presentations, and then we will open the floor for questions, which will be moderated by Quentin, and I will sit next to him to try to feed in the online questions that I will get hopefully on my iPad. So please do send your questions through the chat box and they should appear, and then we can hopefully feed them in. After the Q&A session, we will finish around 5, and we will have our well-deserved drinks and continue our discussion. And then around 7, we have to go out of here. That's the plan. So without much further ado, I would like to give the floor to Jillian to kick off the 8th annual EFILA lecture. Thank you.
Is this on? Okay. So thanks so much for having me, first of all. I think it's important that we dig into the question of what ESG is before we talk about kind of development of systems or disclosures or regulatory frameworks or any of that. So as was so helpfully included so far, ESG stands for environmental, social, and governance. And it's an umbrella term that's used to refer to the environmental, social, and governance performance of an organization. And it's often used by investors as sort of a map or a combination of guidelines that help them decide what they want to invest in, but it has kind of grown. There's been a bit of mission creep about what ESG actually stands for. To differentiate it from corporate social responsibility or CSR, that is a business management or governance concept where an organization tries to create positive impact. So if you think about an organization that's doing volunteering in their community, that was historically part of their CSR efforts. And that was largely self-regulated. And really focused on the idea of the marketing, which sounds a little jaded perhaps to say, but it was more about saying, well, this is the type of company we want to be able to portray ourselves as, whereas ESG is hopefully something that can be more quantitative. So you can actually measure these different factors in a way that you could increase the value of your company. But I think when we think about what ESG is today, it can be put into three main buckets. So the first is the ratings and rankers. When ESG was kind of first developing, the idea was, well, you've got this list of factors and various rankers will be able to give you a rating that can say you're the best in your industry because you have checked the most of these boxes. That still exists, but there is also a movement towards saying that is an alphabet soup or alphabet Greek salad, where we have all of these different ratings and rankings. If it's everything, is it now nothing? I mean, does this mean nothing to us anymore? So there are two other offshoots of ESG. The first being the frameworks or systems, which tend to look a lot like CSR, honestly, within a company, of saying we're going to look at our environmental health and safety management system, our ethics and compliance system, and try to make it more focused on ESG and have all those people at the table at the same time. And then the third, which we'll be talking the most about, I think, is related to disclosures. So a lot of regulators around the world stepped up and said, this is craziness. Like, we don't even know what's happening. Let's try to standardize this because we do want to reorient capital flows towards sustainable investment. And one way that we can do that is we can regulate disclosure. So you'll see that there are a lot of new regulations that are either freshly proliferated or in process. For example, in the EU, you have the Sustainable Finance Disclosures Regulation, which is sort of halfway in force. And as of January 1st, 2023, level 2 will come into force, as well as the CSRD in the EU and all of the other sort of directives that go along with the European Green Deal. But you also have the pending proposed climate-related disclosures rule in the US coming from the SEC, which is getting a lot of pushback, as no one should be surprised. But one of the key things to keep in mind is that the EU and the US are far from the only like large global players moving in this direction. And so that leads us to a place where more and more organizations, funds, companies will be forced into disclosing information on ESG factors. And that increases transparency, but also increases risk and litigation risk and reputational risk, because at the point that you said something, does your audio match your video? Do you have the metrics to say, yeah, we said we were green and safe and climate neutral, and then somebody looks at all of the information that you have had over the past 5 reference periods and says, you haven't improved at all. And what was this goal? Did you even try? So that's kind of the direction that we're moving in. But I did want to point out too that ESG has been scrutinized a bit for being overly broad. So we said it's environmental, social, and governance, but what does that actually mean? There's been a lot of focus on environmental, in part because climate is trendy right now, which is rough to say. I mean, we all live on this dying rock together. And so there's a reason why climate is trendy, but it also can't be seen in a vacuum. So E can be climate and GHG emissions, deforestation, water and energy use, waste management, legacy liabilities, but it could also be treatment of animals. And the S is often shunted to the side right now, but it can be diversity, equity, inclusion, workplace safety, fair compensation, conflict minerals, any sort of discrimination on race, gender, or sexuality. But it could also be free, prior, and informed consent from tribes, which you can see sometimes if you look at like the Equator Principles framework. And I think that you can also see the overlap in these 3 areas when you look at G for governance, because that speaks to the policies and conduct of board members and C-suite executives. And so that can sound kind of out there, but that could mean looking at the composition of the board and saying, is your board actually diverse? How do you define that diversity? And I think that it's crucial to keep in mind that while climate may seem like it's just about GHG emissions, if you look at the Sustainable Development Goals, you see that there's a huge amount of interconnectedness because, you know, I don't know where the quote comes from, but there are no jobs on a dead planet. So, so if you have issues where you have climate impacts that are creating extreme heat, then that can also create changes in the way that you think about how people live in cities and where they might move to. And if they're going to move there, are there systems in place for them? And so a lot of the issues that are currently being addressed in S&G and maybe not key focus, I anticipate will become a greater part of the conversation as more and more data gets generated from this, this new sort of focus on disclosures. But even though I could probably talk about this all day, I think I will leave it there for the moment, and we can come back to some other things at a later point.
Thank you, Gillian. It's a great introduction. Good afternoon, everyone. Maybe I'll try, as Nikos mentioned, to make it a bit more practical, what it means for a large multinational company. How do we handle ESG? But also maybe to start with also providing a bit of additional background, maybe a bit about why is finance looking into ESG? Why is it a hot topic? I think there are a number of reasons. On the fashion side, I think 2019, Greta Thunberg really raised the global awareness more than anybody else on climate. And this is really, you know, started the impulse. We'd had Mark Carney, the governor of the Bank of England previously, but far less success than Greta, I have to say, even for the investor community. So this really got the ball rolling. And as a practitioner, previously investor relations would probably call me maybe once or twice a year. Like, we have a question, we have a call with these shareholders, they want to know about this or that, whatever. Normally, these were shareholders from religious groups, so running money maybe for the church or something like that. And these were basically the only ones asking questions about environment, what we were doing for access to medicines or whatever. In 2019, that started to change. 2020, we had the pandemic. So I think there they suddenly started to realize the S was somewhat important as well. The healthcare was important, the interconnection, and now 2022, it's a bit early to say, but the resilience becomes even more important with what's going on in Ukraine and the impact it's having overall on supply chain companies, globalization, and so forth. So there is, of course, there is a lot of interest now from the investor community. They can also make more money out of ESG. The climate's changing again, I mean, the investment climate, but at a time when you had negative interest rates, it was a challenge for investors to make any kind of money. And ESG was an interesting new topic where they could charge higher fees as well to companies, to their clients, and so forth. So that's probably one of the important reasons. And then you have risk minimization, because it's probably the only, from an academic perspective, the only link that can be made today quite solidly between ESG performance of companies is less volatility in stock prices, better risk management. So there is an investment case, at least on that side, to look at ESG performance. And then more from an EU, so this is very much the way the US investors look at ESG. And then on the EU side, as Gillian mentioned, because of the SFDR and the EU Green Deal, there's a real political will to sort of bring the money into the green transition. And in order to do that, so they put in a lot of regulations. And so the EU investors, due in part to regulatory pressure, they're really looking at the E and making sure that they are shifting the money, not out of the brown into non-polluting, but really from the brown to the green, which is what EU is trying to achieve. So this is really important. And then, of course, then you have some investors that are also interested in impact. You know, how can I make sure that my money has a more impact on, you know, on society and the environment and so forth. So this is more around the why. And then we have the challenge of the Greek salad, which is the what Gillian mentioned, Nikos mentioned. And I just want to make, I think the analogy, if you're familiar with this Indian mythology story of the blind man and the elephant. And I think this very much illustrates ESG. The story is that they bring about, I think, 6 blind men in front of an elephant, and then they position them around the elephant and they ask them to touch the elephant and to say, you know, what is it? So the one that touches the trunk say, oh, it's a snake. And then the one that touches, you know, the legs say, oh, these are pillars. And then the one that touches the flank of the elephant say, oh, this is a palace, this is a wall, whatever. And this is really what ESG, I think that's part of the challenge, because everybody sees something different and has different expectations. I mentioned why the investors are looking at this, but it's also the underlying of, because ESG comes from CSR, as Gillian explained, and CSR comes from different currents, basically. So you have what we could call the moral side of CSR, which is very much challenged today with all that's happening in Ukraine, for instance, because which is probably the oldest part of CSR. As I mentioned, only the sort of the church investors were reaching out to us 5 years ago. Then you have the more utilitarian approach, which for me is more the EU approach, where they sort of using the stakeholder approach, saying like a company cannot, I mean, you mentioned in a dead planet, but also, you know, in a planet where more or less everyone is relatively happy, your suppliers can live, your employees can raise their children and so forth. This is the whole stakeholder approach. So the CSR side of thing is more like, as a company, how do I make sure that I keep everyone happy? The shareholders, of course, they're still around, but also the other constituencies. And this is a bit of shift from basically, you know, the Friedman Chicago principles. That's another side, of course. And then you have the more public side, which Gillian mentioned, the sustainable development goals. So how do companies contribute to sustainable development? So you have basically those 3 streams. There may be other streams, but these are the ones that I consider the most important, that are informing basically the ESG approach. And the challenge as a company is, how do you more or less satisfy those different approaches, which do not always align properly, but somehow you have to show the moral side, show how you please the stakeholders, and also how you contribute. And so as a company, the challenge with now the fact that ESG is really integrated into, you know, the investor questions, the dialogue with investors, is how do you properly integrate? I think indeed CSR was a sideline, more of a communication exercise. You could potentially put it in your strategy, but it was generally, you know, the last pillar. And if you look at what's going on, if you look at the company's website, it's still very often the case. Like you have, you know, the business, whatever, you have some kind of strategy, and then in the end they say trust or whatever. So it comes as the last piece. So the challenge for us is integration. How do you link it directly with your strategy? I think this is one of really the key element, and this is what today investors are expecting. It will also ensure the sustainability of what you're doing. And so just to give you an example, because we worked on that in 2019, we were running all our access to medicine, which is a key issue for the pharma industry, more as a philanthropy thing. Basically, okay, we have to handle donations, we have to run programs on our own money, whatever is left. And the challenge is, as the strategy evolves, as the company fares well or less well, the budgets, they go up and down. And it's a real challenge to have a sustained impact if you're just relying on philanthropy. So we try to shift that into social business. I will not go into detail right now, but this is just to give you an example. So focusing, what are we doing as a business and what we can do just a little bit more. So it's all about integration. If you mention integration, in order to make it work, you have to link it to compensation. It has to be in the company's objective. It has to be in the director's objectives. It has to be in your CEO objectives. Otherwise, nothing happens. But the moment you put it into compensation, and this relates again to Gillian, disclosures, measurement. It has to be very properly measured. You need to be able to track it over time, and you're no longer allowed basically to change the goalposts, because you're talking about compensation, you're linking it very closely to finance. So you cannot afford, as we used to do. I mean, if you look at even us as a company, like our climate goals, you know, we shifted the goalpost year after year up to probably 2015, where we started to get a bit more serious. And in 2019, we actually considered 2019 is our baseline year, because prior to that, honestly, the measurements were not great, and we kept moving the goalpost. We're changing basically before you say like from 2020 to 2020, and then you switch, you say from 2012 to 2018. So you lose everyone, and you're driving your own objectives. Now, what you need is, and what the investor community is asking, targets, you stick to it. Basically, it's just like your financial guidance. Targets, measurements. This will also involve assurance, which is a key element to bring trust into all this ESG data. So this is the job basically of what we have to do as a person responsible for ESG in a company, is getting all this into order and making sure that our disclosures are investor grade, if I may say. Because there's a huge, as Gillian mentioned also, there's a huge challenge around data. And this is where there's a key business model for rating agencies today. On the one hand, they provide judgments. They provide, because you have a lot of people who don't have their own ESG teams. So basically they rely on external judgment. It also, from a responsibility perspective, it's, you know, it's a bit like the credit rating agencies. It saves you from your own responsibility and your own judgment. Say, I relied on whatever rating agencies. They said that company was great. I don't understand, you know, what happened, why the dam broke. No clue, but this is what happened. But they were very well rated. So at least you're not responsible because you're relying on somebody else. So there's a whole business model around that, on the judgment, but even on the data, because now they want more data because they need to understand what's going on. They're trying to do benchmarks. And no one is going to crawl to all the companies' ESG reports, websites, Excel files, whatever. So these rating agencies will be pulling up the data from the different companies. And there's a huge challenge in terms of data assurance and data consistency, because we are spending our time as an issuer going back to the rating agency and saying, you got our CO2 figures wrong. They're published, they're assured, they're in our 20F. Why did you get it? And we need to correct that all the time, because today the business model compared to the credit rating agencies, we pay the credit rating agencies. It's another story. But in this model, it's investor paid model. It's research, it's considered research. So it's the lowest paid part of the investor community. So the business model for all those rating agencies is very challenging and is still a struggle. So this is where we basically, I will stop here. This is where we stand today, just to give you a glimpse of, you know, the challenges we are facing, and still a lot of alignment to be made. Thank you. If you like, if you have a few points.
Yeah. So I think that there are two main areas that I would just highlight. One is that the data is really challenging, and it's only going to get more challenging insofar as when I said that scope 2 of the SFDR, or rather level 2 of the SFDR will come into play in January, we start moving into an area where you need to be thinking about not only scope 1 and 2, but also scope 3 GHG emissions, which is the difference between direct and indirect GHG emissions. And 1 and 2 are the tip of the iceberg, and scope 3 is everything else. And a lot of companies are going to face extremely difficult uphill battles, looking at how do we get that data, how do we verify that data. And while we can anticipate that rules like the SFDR don't actually have any internal penalty regimes right now, they're going to be sort of under each member state. that's going to still be an issue because as time goes on, the line of, oh, we exercise best efforts is not going to be sufficient. So I think that that's going to be a big challenge for a lot of different organizations. And additionally, there isn't great standardization among the rules. So for companies who do business in more than one location, then they need to be looking at all of the different frameworks. So for example, the EU rules have human rights disclosure obligations, but the SEC's proposed rule does not. And some of the EU directives and the SEC proposal impose civil liability, but the CSRD does not. And the CSDDD imposes director duties on EU companies, but not non-EU companies. And the SEC does, but the CSRD doesn't. So that's the type of thing where you're kind of mapping out this spreadsheet and you're saying, well, what can I say then that is going to be correct in all of these different frameworks, and knowing that there is going to be more and more scrutiny on that is a challenge, I think, for a lot of different organizations. But it's one of those interesting times where, as Laurent said, it's not solely about law. That's not the sole motivation. It's also about reputational and strategic risk and sort of a company's profile, which creates, in my opinion, an interesting role for arbitration and dispute resolution, because there is a lot of litigation, not a lot, there's a lot of litigation in the US, some in the UK, and more coming when it comes to ESG. But there is also a lot of consideration of how do we fit this into contract terms in a way that maybe we could arbitrate it, keep some of the scrutiny off of us if this goes wrong, and try to think creatively about what this looks like for us, because the law is still uncertain in a lot of ways. And perhaps if we took another avenue, it would help to mitigate some of that. If that's of interest, we can talk about it in greater detail later, but those were some of my initial reactions and thoughts.
Maybe if scope 1, 2, and 3, I don't know if that's a challenge for you, but just to give you an example, our company, scope 3 is 85% of our carbon emissions. And basically those 85% we don't control directly. And this is where we have to make most of the efforts. And to be honest, we don't really know how to go about it. We've mapped our 100 largest emitting suppliers. Now we're reaching out to them. It's a bit of a carrot and stick situation, saying, what are your plans? Hopefully everybody has made great plans for 2030, 2050. So if everybody sticks to the plan, we should be okay. But we know, that it's going to be a uphill battle. We started reading because of the current situation, that this may jeopardize all companies' efforts in terms of reducing energy use, switching to renewable energy, and so forth. And yes, it is a huge challenge. So just to reflect on that particular side of things.
Okay. Hello, can you? Okay, fine. Just perhaps to a broad question to both of you first. Is ESG, is it soft law or is it hard law? How do you think things in that stance?
I think that it is soft law that is hardening. Which is, I know, a very equivocal lawyerly answer. But the reason why I say that is because one of the biggest critiques of ESG to date is that you would have frameworks, like I mentioned, equator principles, which represents the majority of the world's financing debt. And the equator principles is a diligence framework that essentially says in order to get financing for a project, you need to meet the equator principles requirements. But the issue with this is that it had no teeth. like a lot of ESG frameworks, and I mentioned with the SFDR, it doesn't have any internal penalties. And can it truly be hard law if there isn't any regime in place to say what happens if you don't comply? But I think the more that we move towards regulatory bodies saying you must disclose, or these are the rules that we're putting in place, the more of that you're getting, and the more luck parties have in court, the harder it becomes as well. Because I think that you have to take it seriously at the point that folks are winning in court on issues of saying you made materially misleading statements that fall under the ESG umbrella, or you need to be liable for the actions of others within your supply chain. If that starts to become something that has a lot of merit in court, then I think we'll move more and more in that direction. And of course, the more money is tied up in something, the more real it becomes, because right now you can contract around some of it, but when you hit the promised date, let's say you had a 2030 goal, even if that's just related to trading carbon credits, at the point that you're not there and the date is here, then what are you going to do about that? So I'd say ESG is still developing, and there are things about it that are soft and certainly uncertain, but it gets more and more real and tangible every week, it feels like to me.
Oh,
Yeah, well, there are a number of hard laws that have come into force. If I take in France, we have the duty of vigilance law. And these hard laws, they reference to soft laws, basically. So it's a very clever situation, actually, where they actually managed to make those, like the Equator Principles, the OECD principles, they somehow turn them into hard laws, because when the judge, because the duty of vigilance law is only 2 pages long. So you can imagine that the criteria are not defined. Okay, to just say environment, human rights, health and safety. That's it. So when the judge or when the parties are trying to set up the case, they will be referring to whatever existing criteria is available. And they're using all those soft law principles that have been developed over time. And for me, so in a sense, these hard laws are turning the soft principles into much harder principles today, and providing them with teeth, in a sense.
thank you. Now at this stage, I would like to turn to the audience. Is there any question? Yes.
So the question was, how urgent do I think it is in terms of the timeline for it going from soft to hard? I think that personally, it appears to be fast tracked insofar as there is actually a really interesting study in Sweden that was showing that most of it was basically mapping light green and dark green funds, which are Article 8 and Article 9 funds under SFDR. And it was looking at the fact that even as the stock market became more and more turbulent and active savers were selling off product, that in fact, there was a massive inflow to dark green funds. And I think that while the transparency that is promised by ESG regulation isn't there, it's not perfect, it is underpinned by huge interest from the public that is forcing momentum in this area, where even if it doesn't apply to you, I think it's getting to the point for industry where it's like, well, but we need to be talking about this in some meaningful way. Otherwise, it's going to hurt our bottom line. I think depending on where you are, like in the US, a lot of the momentum is going to depend on the next election, frankly, because there's going to be litigation over this rule, and depending on who's in power, that makes a big difference. But I think globally, this conversation is picking up steam. It's mainly just going to be about whether or not regulators can get it together enough to generate rules and systems that work and don't kind of trip over their own feet. But I would say that within the next 5 years, I anticipate seeing significant, meaningful information coming out of ESG that is usable for any number of industry, investors, stakeholders, plaintiffs, etc. So I don't know. No, I'm not an oracle, but I'd say 5 years is what I'm hoping.
Thanks very much. I'm just calling on our online participants to type up their questions. I've seen there are some high-profile friends online, so don't feel shy, and we try to feed them into the debate.
In the meantime, anybody else has a question, or yes, please.
Thank you much, Memkes. You've both touched upon the multiplicity of different reporting standards, soft laws, and so on, and you made this interesting comparison of reporting bodies and methodologies as opposed to credit rating agencies. Do you expect that in the upcoming years we'll see emergence of several dominating players for the purposes of ESG ratings? And if so, which should be the funding model? Because we know that both the company side and the investor side as the actors financing the rating agencies or ESG rating agencies create or entail risk of certain pathologies.
Well, what's happening currently with the rating agencies is that there's currently a lot of consolidation already, and most of them are ending up under the umbrella of existing credit rating agencies. So for instance, you have, if I take Standard & Poor's, they have basically gobbled up the Dow Jones Sustainability Index, which used to be run by Robeco Sam, a Swiss boutique. So that's just an example. And Moody's, another big credit rating agencies, they are now the owners of Vigeo Eiris, which was basically the merger of, I would say, the French boutique and the UK boutique, because all these rating agencies started as boutique, and they were, I think, catering for a very small portion of investors. And as it becomes mainstream, they couldn't keep up, and they've been bought up by those credit rating agencies. And Standard & Poor's, for example, is now offering a product which is very similar to a credit rating, where the company pays to be rated. So they have it's interesting because they have both products today. They have the investor paid model, where it's a bit like Facebook, because the company is the product, and we provide information for free, in a sense, the rating, and we have to, if we want to make sure that we are properly reflected. But now they created also a product very similar to a credit rating, where we as a company, we pay Standard & Poor's, and we get a very thorough rating. And they have all this process, and they actually do. I think the main difference is, as a company, it's interesting because you're able to provide more color, more context to what's going on. They have interviews with board members. It's a very different exercise. And considering all that we said before, there's so many topics, difficult to balance the E, the S, and the G. Just filling in Excel files, I think, is not the proper approach today. So something looking like a credit rating agency, and probably it will have to be financed by companies, may be part of the solution. And you may be aware also that ESMA, the European regulator, has over the summer has run a consultation on these ESG rating agencies. And it's likely, I understand that the outcome of the consultation, that everybody's pushing, either from the issuers, but also from the investors, are pushing for this industry to be regulated. So then I think once it's regulated, I wouldn't say the conflict of interest would disappear completely, but I think there will be more transparency on methodologies, more transparency on fees, on services that they're allowed to offer, not to offer. I think the challenge today compared to credit rating agencies, and there have been many studies, is that if you take a given company, you take the 5 main ESG rating agencies, and you can be first of the class in one rating agencies and number 10 in another rating agencies. And they all get the same raw data, basically. The judgment is different. It's a challenge. Or there was a spat over the summer because, and this is, I think, also the challenge between E, S, and G, where I think it was also because of all that was going on. Tesla was kicked out of, I can't remember which index. And of course, Elon Musk is always, I mean, you know about it straight away, okay? At least he's very vocal about it. And ExxonMobil was put that on that same index. So he was saying, well, and this is the challenge I mentioned earlier, is it risk minimization, which I think was what the rating agencies were trying to reflect, because they had questions on governance at Tesla, which makes sense, but not on the environmental side. Of course, Tesla is pushing for the transition in mobility versus ExxonMobil, which is still, very much a fossil fuel company. So.
And you both insisted on the divergence in terms of regulation between different jurisdictions. And a question to Laurent is, how does a company like Sanofi deal with those differences?
Well, the challenge we have, to make it simple, we are listed in the EU, we're listed in Paris, but we're also listed in NASDAQ in New York. In the EU, we are already faced with very strong regulatory disclosure requirements that are going to be even stronger with the CSRD, but already. So we have 100 pages, basically chapter in our French regulated annual report on ESG, and in our 20F that we file in the US, that chapter does not exist. So for us, this is a bit of a challenge. So we sort of publish that chapter on the side, we translate it into English, and we publish it on the side. We haven't had any issues up to now of a US investor coming to us like, we're not getting the same level of information compared to our EU peers, because that chapter, first, I don't think they'll look at it. And secondly, it's there, it's on the website. But from a strictly legal, regulatory, it's a real issue. And if we talk to our legal people, they say, we're not putting this in the 20F. This is, we're taking a huge litigation risk if we do that, of course. And we even have the issue of the assurance report, because we have an assurance report from the auditors where this has been very well organized in Europe. They are accredited, they are vetted and so forth. So it's no longer voluntary assurance, it is regulated, but they're not ready to publish that assurance report towards US shareholders, of course. But and if we look at what's going to happen, that divergence is going to stay for a while, because the best we're going to have is a bit of climate in the 20F if the SEC regulations go through, but nothing else. But in the conversation with the US investors, we get the whole story and the controversies, and they focus a lot on legal issues, controversies, strange.
And
Did you just
yes,
say that was strange? Well, I mean, if you were as litigious as the US is, like, of course, we're focused on that. I think that one of the challenges is when we talk about ratings is that I do think that there's been more gravitation towards some of the ratings and rankers, like the GRI model has been a bit more respected as a rating. But I agree with you wholeheartedly that at the point that there's more oversight of the ratings and rankers, that it will probably get narrower and narrower until there are fewer of those. But that should also coincide with an increase in the amount of data that's publicly available. So if an investor is willing to put in the time and say, I'll look at your 20F, I'll look at the statements that you've put out, maybe you don't need a rating, because rather than getting the spin that has the interviews with the C-suite, instead you're saying, I want to actually look at the things that are important to me. Because I think one of the challenges with ratings to date is that ESG has been very bespoke. And that's great, especially for startups or companies that don't need to report because they don't reach the number of employees that you need to have. But that means that you can cherry pick from the list of what you want to be reporting on or what you think ESG means for you. And I think that means that the ratings come out looking really divergent even for the same company, but the data that underpins it is still the same. So if that's available, that should make some changes, I think.
You had a question?
Thanks. Gordon Nardell, I'm a disputes lawyer, which means that I tend not to be in very close contact with discussions within the management of companies. But actually, I'm really keen to know within companies, the G part of ESG, at what level of company are the E and the S typically being discussed? I mean, there are certain things that we all know. The main board in a company of any size is going to deal with asset disposal, acquisitions of any size, major litigation trial against the company. But in relation to the E&S, is that actually being discussed and debated at main board? Or is it shunted down to another level of the company? See, the problem is it's not being discussed at main board. And from the dispute lawyer perspective, there's going to be a disclosure because the board have got to sign off on the prospectus on the disposal of a significant part of the business. If they're not also debating where the company's going in terms of the E&S, particularly the E, if you've got investments in assets that are going to be worthless in 10 or 20 years' time, you can see the disputes and the liabilities coming down the track. So I'm really keen to understand whether the E and the S are actually being debated at main board level, whether that's part of the G. It seems to me that if it isn't, then there are going to be other things debated at main board level, which are going to get rather hot and sticky for the company.
Well, it is more and more debated. And there are two sides to the coin. One of the reason is because board members are, they also live in societies, they read the press, so they are more and more interested in those topics, and they want to find out, what's going on, what are we doing, how are we keeping up with this issue. But there's also soft and hard law pressure to make sure that the board, that a certain number of topics reach all the way to the board level. For instance, if you take climate, the task force on climate related financial disclosures, TCFD, basically more or less requests that climate discussions take place at board level at some point during the exercise. So when, as an issuer, you publish your TCFD disclosures, basically there's a section on governance where you have to explain who's accountable, where have the decisions been taken, and so forth. So yes, these discussions are taking place at board level today, especially on the E, also on the S. I think the challenge, and this is something that investors are asking, that the challenge we have today is the education of board members. And it's also an overall challenge, because now the investors, they want the board members to be, ninjas in ESG, in cybersecurity, in risk management, and they also want the boards to be as small as possible. So you're always looking for the magic board member that doesn't exist, because you would not get a board member that has all those competencies, experience over time. So board education is a key element, probably first on climate. And this is something that's starting to happen. And then eventually on the other topics. Yes. Yeah, definitely. So for instance, in our company, we were quite proud of it because it was a nice move at the time. We have a non-exec board member who has a real ESG experience. She used to be the director of the UN Global Compact. So, I mean, she brought in the discussion at the board level, and she's also sort of educating the other board members. The challenge also is, do you keep it in a separate board committee? Or do you make sure the discussion always takes place at board level? Which is
I think that's one of the benefits of what ESG ideally should be versus CSR is, historically there was often a person at an organization who was the sustainability person. or the environmental person. And they would be the last person called in on any deal or transaction. And someone would be like, you can sign off on this, right? And you're like, and I think the idea of ESG is trying to break that and say, you should be thinking about who is on your internal team before the night before you want to close the deal or you need to report, because these functions are not actually divergent from one another. Now, that can still be really challenging, both thinking about internal and external teams, because it's difficult to have a very streamlined board where you have all of this expertise. But I do think that there's merit in thinking about what expertise do you need, and do you have that? Or are you going to try to force someone into being able to sign off on it at the last minute? And to the extent that boards and C-suite individuals can be thinking about those questions earlier on in the process, I think it results in better outcomes for the organizations and for everybody else that they kind of touch. So.
Any other question? Yes, please.
James Roll. I had two questions. First question is, how sensitive are stock prices to these ESG disclosures? And the second question together with that is, do you see a role for short sellers to play in checking the accuracy of these disclosures?
Well, in some cases, it really depends, and there are links to the stock price sometimes, and sometimes there are no links. I think it depends on the overall news flow, in a sense. It's difficult to say. I don't think there has been any documented, I would say, attack on companies based on ESG topics, trying to, to organize a short sell or whatever. But maybe elaborating on this question, I think today, this is also something I wanted to say in the introduction. If I look not the equity side, but more on the more general financing sides, the bonds and things like that, today the financial system is not equipped to set up the proper incentives, basically carrot and sticks, on ESG. If I take the example of sustainable linked bonds, whereby you will issue a bond tied to ESG targets, and the way it works is that you will pay a step up if you fail to achieve your ESG targets. So if you're being very cynical from an investor perspective, and from a financial perspective, your objective would be that the company fails to meet its ESG targets because you will get more money out of it. You see the point? Yes, you're putting pressure on the company that it will meet its target because we don't want to pay the step up. And it sets, in motion a lot of things within the company, like compensation. But on the other hand, the signal is flawed, because even in the roadshow, you get to have investors, and rightly so, that tell you, have you been ambitious enough on your targets? Can we bet on the fact that you're gonna, miss the targets? And you're like, well, is this sustainable finance or not? And we don't have the mechanisms. I don't think we don't have the proper mechanisms today to really finance the transition. There's still a lot of work on this one.
Gillian, do you want to add anything?
I agree with that. I think as of right now, there's a little bit too much unpredictability related to how a disclosure would impact price, but you mainly see it in the context of the US because we litigate over everything. That if you have a court case or you have news coverage that is tied to your disclosures, then that would be more likely to impact the share price. But that's not really specifically because of the nature of the disclosures, but more because of just the impact that press often has on an organization's public persona and perception of its stakeholders and shareholders.
Any other question? Then I had a question for you, Gillian, because it's still not very clear to me we're talking about litigation risk, but what are they concretely? What would be the legal basis to bring a case against a company? I mean,
Yeah, so I'm glad you asked. So-
And then in terms of risk, is there any risk of fines from companies if they disclose wrong information?
So, I mean, if you look at the EU, I had mentioned that you're going to be looking at each member state separately because of how the oversight works. But a lot of the claims that have been brought so far, and take into account that mandatory disclosure hasn't really been a thing for that long, so it's still developing. So previously we had most of the claims coming out of tort and contract primarily, of saying that you were negligent, that there was trespass, that there was something about how you were actually operating more so than the disclosure itself that ran afoul of these rules. And now we've seen more and more litigation that is speaking either explicitly to greenwashing, of saying, well, you made this claim, but it's really just not true. You did it because it increases your image under CSR, but you have nothing to back that up. Or we've seen a lot of cases, particularly in the US, related to securities litigation, saying you made statements that were materially misleading. And when you look at those cases, it's interesting because it almost seems like there's no pattern in terms of when the court decides that it was materially misleading and you have a claim versus not. There's not a lot of clarity, but those claims have been successful quite often. And then there's the additional layer of climate related litigation, which tends to be at the intersection of climate law and human rights and is often brought against both states and companies. There have been some very high profile pieces of litigation. And of course, Shell is one of the.
Do you
the
think
folks that we
cases like
have.
the Shell case we'll see more and more cases like that one in
Yes.
Europe?
That was a concise answer. Yes, I do think that there will be more litigation, especially because if you give people more information, then you give them more basis for a claim. So I don't know why that would change. And I think that these, the idea that we're going to meet Paris seems challenging right now. And so I don't think that miraculously I'll wake up tomorrow and climate change will be solved. And I think that's what would need to happen if you really wanted to see that litigation die off. And I did also want to highlight for this audience, for anyone who's interested, that because of the nature of the ESG conversation, there's also been kind of this creation of sustainable investment agreements, where states are saying ESG is going to be part of the way we think about treaties and how we deal with outside investment. So you have the EU Angola Sustainable Investment Facilitation Agreement, which its negotiations are supposed to be concluded tomorrow. And the Australia-Singapore Green Economy Agreement, which is supposed to be signed next week. And for other terms that are kind of interesting to look at in terms of the transition of soft law into hard law, or that kind of fine line between trying to work all of these documents together. The Gambia has a Sustainable Investment Facilitation and Cooperation Agreement that draws on the UN guiding principles for business and human rights, and can be really interesting when thinking about, yes, ESG can be corporate, it can just be disclosures, but it is also a larger global conversation, in my opinion, that is kind of trickling down into a lot of different types of contract forms. And the more that happens, the more we see litigation and disputes sort of having a basis and having claims arise out of that.
I think Nikos has a question.
Well, just to follow up, and again, I'm encouraging our online participants not to be shy, but I think that this is really something interesting, because indeed you see also in the newest agreements of the EU that you have CSR obligations, but the issue is, what is the dispute resolution mechanism? Right? When you look at it, for now at least, it's often kind of like state-to-state WTO style panels of specialists that would kind of hand down a report, and then it remains for the parties, the contracting parties, to sort this out, right? So it remains a state-to-state level, whereas obviously the potential damage has been done by one of the private parties / a company or investor, right? So the question is this a suitable dispute settlement resolution mechanism, or should we change this, or and if so, how? I mean, you see that in some instances now the EU is kind of like opening. They have this. I forgot the curious name. They have a certain spot or point. They have. You can complain point where NGOs and trade unions can complain about the behavior of an investor, and kind of like help enforcing through a third party amicus curiae style, and kind of inviting the Commission, in this case, the European Commission, to act and to investigate. So my question is, going forward and giving teeth to all these standards, what would you see in terms of treaties, right? So investment trade treaties, how would you see a dispute settlement mechanism that maybe works better?
I feel like if I had that skill, I would have a different job. But, like if I had all those answers. I think that right now with ESG, we're still in a phase of trying not to let perfect be the enemy of good. So even though you may not have ideal disputes resolution terms, you still are kind of glad to have it be included because it increases the overall profile and therefore gets you to a place where you can keep the momentum going and hopefully get more change in a shorter period of time. But in terms of how to actually reach like real or meaningful dispute resolution terms, I think that we would need to be in a position where you, one, make it visible, because I think about the fact that there is an entity that is in charge of doing all sorts of research related to the former North Atlantic Free Trade Agreement. And it's a joint effort by the US, Canada, and Mexico, except no one in any of those countries has ever heard of it. And so you could reach out to them and say, could you please, like, I'm a private citizen. Can you please do a research into tar sands for me and do like a full investigation? But no one uses it. So I think making sure that everyone is actually aware of what the terms are and making that more public would help to strengthen terms. And then additionally, I think forum matters a ton. And that's one of the large challenges with ESG just as a concept, because especially for organizations that are in a bunch of different jurisdictions, often you end up in a situation where it doesn't seem like there's any good place to be having this argument. And I think you can even see that with some of the climate change litigation, because you're like, well, it really affects the whole planet, but the whole planet can't be part of the litigation. And I think those are kind of the two main aspects that I would say would need to be improved to have terms that were more meaningful in terms of outcomes.
Thank you. Anyone else? No, then I had a question. What can be done to make it easier for companies to adapt to ESG? What especially companies that have yet to start their journey on ESG?
Well, I think I think the challenge is clarity, because I mean, we've been on this journey for a while, so we've been adapting year after year to regulations. We have a very clear strategy, storyline. We know what are our key topics. I think and I know that with CSRD, the threshold of disclosure for companies is going to become very low. What I also think is, I mean, it's probably best for, especially for smaller companies, just to set up simple sectoral standards. It may not be perfect, but same story, but it will be good enough. Saying, if you're in this industry, this is what we want you to report on. You know, this is what you need. If you want to report on this as extra, just do it. But this is what we're expecting from you. Maybe, I don't know, something on health and safety, everybody carbon emissions, whatever. Keep it simple so that people can get started. And you have also, as a result of that, a level playing field. But if you leave the companies saying, okay, you need to report on ESG and don't provide any guidance, you don't know where to start. I think it's a real challenge. And I think the regulations should be prescriptive in a sense, and saying, you're in this sector, you're in these geographies, these are the 5 things we expect from you from a disclosure perspective, and the rest is up to you. Because, I mean, we're in a sector, and if I look at the disclosures from all my peers, we basically all disclose the same thing, more or less. Anyway, we look at what our peers are disclosing, what the questions we get, and then we more or less, adjust. And this would work, I mean, for all industries, for sure.
Gillian?
Yeah, so when I've had clients come to me who, let's say, are in the fintech space, or they're more of a startup, they know that ESG is something that perhaps they're getting interest on in order to get financing, or they've just sort of heard about it and they're like, we don't want to be behind the 8 ball. Usually I suggest that it makes sense to create a checklist for an organization and say, what do you think are your big picture ESG issues within, at the beginning, I was talking about forced labor and conflict minerals and deforestation. And depending on the nature of your business, when we talk about Sanofi has a very different set of considerations when it comes to ESG and prioritizing ESG categories as you would get in a company that, say, makes paper and pulp, or Spotify. Like, all of those companies are kind of dealing with different challenges. So saying, what is the nature of your business? Let's try to create a checklist to help you navigate then answering the question of, who do you need on your internal and external team? Do you have the expertise that you need? And if not, let's try to think about how you could get ahead of that. And then additionally, trying to say, to the extent that there are templates within disclosure regimes or guidance documents related to rules that apply to you, try to gather those up and maybe convert them into a form that you can actually edit. So you can start somewhere. And these are sort of like basic rules and approaches, but it can help to make it seem more manageable, because I think ESG can seem so large that it's like, let's try to get it down to some steps that anybody could do, essentially. And then the last point for me is just trying to plug into good sources that can help you keep track of regulatory developments. Because there is a lot of uncertainty, you want to know what's happening in your industry in terms of what are the trade organizations doing, but also what do you think is happening among the regulators in all of the areas where you might want to show up. Because the other point that I'd make, as a climate change council representative here, is that unfortunately, ESG, if you're just talking about disclosures, is not enough. Like, it's the floor, essentially. So you want to comply, but if you actually are talking about saying, I want to be at the forefront of this issue, I want to be innovative, cutting edge, I want to be prepared for extreme weather events, or whatever the situation is, then that requires a different approach. And having a sense of that kind of trend and how you could really get ahead of it once you wrap your hands around the initial issue of ESG it's always good to be ambitious, I think. It can't hurt to be ambitious.
We have a question from the online audience, and the question is on greenwashing. What are the panel's thoughts on issues around carbon offsets? KLM were recently sued for exaggerating the benefits of carbon offset they sold passengers. JP Morgan reportedly spent $1 million protecting a forest in Pennsylvania that was in little danger of facing large-scale logging, though there is seemingly no similar risk. Do you have any views on that?
Well, maybe I'll give you a view from a company perspective. As part of our climate strategy, we're basically trying to keep offset, really at the very end, and trying not to use offsets until we don't have a choice. So the way our roadmap is structured, we have a 2030 carbon neutral objective as many companies, which means that in 2030, whatever we have not been able to reduce, we will offset because we don't have a choice if we want to be carbon neutral. In order to meet that 2030 target, we're working right now on sourcing offsetting projects, which are basically our own projects. It's probably not perfect. So we're working in mangrove projects in Africa. We're working in cook stove projects because we also want co-benefits. We don't want that forest in Pennsylvania, basically, even to plant a new forest. But we also believe, because if you look, everybody's made 2030 commitments, some even 2025. So we believe there's going to be a glut of offsets. I think and I believe some NGOs have made the math, it doesn't work out. So we are trying, it's not like Russian gas, but we are trying to secure, good offsets today when the price is still reasonable and we can start, financing the projects that will start providing offset in 2030. We're doing it now in order to meet the offset. But the offset will only get started in 2030 and not before. But there's a huge, I think there's a huge regulation work to be done around offsets because there are different standards. I mean, the offsets, KLM is a good example because basically the offsets you buy when you're flying, or if we organize this event and we try to find out where you're coming from, did you come by plane, whatever, and then we make a check to whatever and say, this is a carbon-free event. And this doesn't fly, really. I mean, it's better than nothing, but, and you don't know how many, how many times the offset has been sold with a given forest. And we have the technology to do that today. With blockchain and everything, we could really do this properly, but today I think we're not yet there. I don't know.
I think that's a really interesting model, because I think of offsets as almost the way that you think about renewable energy, where for a long time, hydro was considered renewable, and until it wasn't, in part because of the impacts that it has on water bodies and impingement and entrainment of fish. And unfortunately, we don't necessarily live lightly on the earth. There's usually an impact, and often the more information you get about something like offsets, you realize perhaps it wasn't quite as good as it sounded when it started. But I think there is still a place for a judicious use of an offset project. But certainly if it is a cornerstone of an ESG strategy, that's probably not going to work well. I think that offsets are just one example of the greenwashing claims that we've seen, though. And this is always the challenge when something becomes trendy and valuable. Because it's not just that people are into it, but they're into it in a way that can make companies more money if they're able to claim it for themselves. And so we had this issue even when it just came to simple products of saying like, oh, this is a green product, literally greenwashing. And folks were saying, well, what does that even mean? And that's kind of where greenwashing even started. And I think as we are still trying to figure out what ESG means, more and more things will probably get called out as greenwashing, whether it's the way that you label a fund, the way that you said you were using carbon offsets, and that's just the nature of it. The best thing that can be done, though, is to say, do you have measurable evidence? Because that's what ESG is supposed to be about, is the quantitative aspect of, can you measure it? And are you confident that you could at least say at the time that there was a clear reason why, you thought that was okay based on all of your evaluation? And so I think it's about thinking very carefully before you speak and not letting your marketing department get ahead of you are the best things you can hope for.
And any question? Yes. Yeah.
with regard to trade agreements and bilateral for Nicholas mentioned the issue of the with regard to these provisions. But even talking about dispute settlement, I mean, the CSR provision that we typically find in those treaties, this is really soft law language. And typically, state should encourage their corporations to voluntarily incorporate CSR practices. So I take your point that in terms of visibility, that's important, but at the same time, with such soft language, the message is a bit lost maybe in the process. So yes, this is important, but at the same time, should encourage voluntarily. So then the audience may wonder what the message exactly is. Then a question, so you say that ESG in a way is kind of a minimum standard of conduct for corporations. So can you elaborate on that? And then what could you do?
Yeah. So the reason why I say that ESG is a bit of a floor and a minimum is because the area is evolving. So for instance, let's take the diversity, equity, and inclusion aspect of the social in ESG. Something that you as an organization may have thought was completely okay 10 years ago, not okay anymore. And that's because of regulation. That's also because of a social awareness and understanding of what is or is not acceptable. And I think that you can see that in a lot of different areas within ESG, where what you are doing day of may be acceptable, but if you really wanted to get ahead of it and be like a truly forward-thinking organization, but also face less scrutiny in the future, you would need to do more. And then additionally, my point about it related to climate change and saying it's not enough for climate change is because while emissions are one major aspect of climate change, like if you just look at the science of it, there are already significant impacts from climate change that affect populations, that affect environments, and simply reducing your emissions and saying, well, I did my part of the group project doesn't actually fix the larger issues of, is your city climate adaptive? Are the places that you do business well hardened? You know, how is your grid? What sort of extreme weather events do they face? What are the impacts on populations who are around the areas or stakeholders within your organization's footprint? All of those sorts of questions still fall under the umbrella of climate change, but are not simply resolved by, say, limiting your emissions or reducing your emissions by a certain date. So if you thought that perhaps by doing your ESG disclosures and focusing on reducing GHG emissions, that would be sufficient, I think it's a bit short-sighted about the overall impacts of climate change and trying to get ahead of the regulatory trends.
Hi, this is I'm Jose Angel Rueda from Madrid. I have a question for you regarding ESG litigation in general. In your opinion, to what extent courts of justice are prepared to deal with this kind of litigation, considering that we have debates about the applicability of soft law or international law that to some extent are alien to the ordinary practice of these courts of justice?
So this is something that I've found really interesting, especially being a US licensed lawyer. So I come from a very litigious environment where that stick motivates a lot of decision making. And I do not think that Europe is particularly well situated from a courts of justice perspective to handle ESG in particular. But that's why I think that it may be somewhat more promising to have the situation of saying, well, yes, these are ESG rules or frameworks, but ultimately the member states and their, let's say, financial bodies have responsibility over considering what penalties or how to implement them, and what that's going to look like. But I think it's a large challenge with the ESG regime in Europe just generally. And I will be interested to see kind of how it plays out, because to date, there has been some movement in the UK, which obviously doesn't count because they decided to leave Europe. But there's been some movement in the UK, which I didn't even really expect to see, because the UK had been more in that trend for decades. And that's changed a little bit in the past couple of years. So maybe we'll see some movement in the EU in that direction. But yeah, I mainly am pinning most of my expectation on the ability of the financial regimes to handle new regulations as though they were just financial regulations, as opposed to saying, oh, well, this is different. It's not that different, realistically.
Then I had a question regarding.
Maybe just to add, today in the EU, most of the litigation is brought forward by the civil society, and they have specific channels in France, for instance. And it's more about reputation, publicity, than extracting large amount of money from companies. I think today that's also, there is litigation, but it's very different in nature than what we see in the US.
And do you think, follow-on question, do you think that it's, in terms of framework, is it also because perhaps the way court proceedings are designed in Europe, does not favor collective actions, class actions? Do you think it can be an explanation why, when you say that the court proceedings that would typically be brought by NGOs or public society, do you think it's an element in that, or not necessarily?
I'm only mostly familiar, I'm not a lawyer, and I'm mostly familiar with what happens in France, especially around the duty of vigilance law, which everybody said, it's a nightmare. It's opening like a motorway for, actions against companies. And there have been a number of actions, but I think it has not turned into something huge, because it's mostly civil society. It's mostly about climate, because they're using it, it's really to raise awareness, raise publicity. There's a more recent thing around plastics, where they've been challenging the food companies around the use of plastic. So I think that this is really and they're not after the money. They're really after, the judgment and the publicity that comes with the judgment, and the fact that they, probably as NGOs, will get recognition around this particular aspect. Because before that, all they had was commercial law, and using the sort of wrongful publicity, if I may say, greenwashing in a sense. Because the first case in France was against Samsung. It was on forced labor, because they attacked basically one of the advertisement of Samsung, saying like a responsible phone by a responsible company or whatever. But with the duty of vigilance, it gives them more opportunity, but it remains civil as well. No.
I had one other thought on this, which is that with some of these ESG rules, it also comes along with diligence terms. And so the things that you would disclose to the regulator, you also are often disclosing to another party in the deal, or looking at it and saying that there are associated post-closing obligations or warranties related to your disclosure structures, which then puts you in a position where if that fails, then you may have two companies taking issue with each other over the contractual terms and the nature of their disclosures, which is why contract has always been sort of one of the cornerstones of ESG litigation, and one of the more successful. And I think that will still be true, because whether or not it's ESG or some other term, if you have committed to certain things within contract and the deal falls through for whatever reason, or you can't meet the things that you said you would, then those two evenly situated companies have a better chance of having causes of action that are successful in front of any tribunal.
Nikos?
Yeah, maybe to add what Laurent just said with regard to the Netherlands, of course, there you see we have not only the Shell case, which I mean, it's now still on appeal, so we don't know whether it's going to be confirmed, but the idea that they have to make sure that their whole chain of operation reduces the CO2 emissions to, I don't know, what was it, 45% lower than whatever date it was. So that's one part. But of course, there is the other part, the Uganda case against the state. And we haven't talked about the state obligations and the government obligations, because we have, of course, also, I think, a similar case in France, not with the same strong outcome, but I think the judge, if I understand it correctly, still ruled that France hasn't done enough yet to meet the Paris Agreement target. So what I wanted to bring in maybe into the equation, since I think we don't have too many questions, unfortunately, from the online participants. We have been talking only about the investors, investors' obligations, companies' obligations, and, well, the NGOs driving the change. But of course, in the equation, I think we shouldn't forget the state. Right. So maybe, I don't know if you both have thoughts about that or generally. So the question, what I want to put on the table is simply, isn't that also something we need to look at, how to make sure that the states implement CSR obligations or general environmental climate obligations, because often they continue to fail.
Yes, just two comments around that. First, on the Paris Agreement, it's a state agreement, and all the companies are trying to relate to that Paris Agreement, but it's somehow general greenwashing, because as a company, we should abide by whatever, the state or the different state request from us, whether it be taxation, whether it be a roadmap, whatever. We don't have that. So somehow, and it's a bit of a lobbying, but this is also what the companies are putting forward when they go to the COPs. They're saying it looks like, at least from an ambitious perspective, we're ahead of whatever the states are being offered. That's one comment on the state. The other thing is around human rights, geopolitics. I think, unfortunately, too often, especially in Europe, and I mean, we can sort of work out the reasons for that, is as multinational companies, we don't have the necessary guidelines from the states or from the EU on what we can do and what we cannot do, what we should do. If I take the situation of the Xinjiang and Uyghur situation, we've got no guidance from the EU whatsoever. So it's up to us to, at least in the US, they have this border protection mechanism. That basically you're taking a risk and you might get, your whatever impounded, and they provide lists of companies. But on the EU side, it's like, we don't have any guidance. We don't know whether we should pull out, how do we make sure that we are not buying there? And this is, this is a real challenge for companies that are trying to implement ESG. I think sometimes there's too much responsibility on companies, and the states are not taking their responsibilities properly, especially in these geopolitical issues. Even for Russia, it's quite unclear. And they put the sanction regimes, but then you have to work your way out. Like, do I have to completely pull out? Can I stay a little bit? What do I do with my employees? You don't know.
I think two interesting areas to watch on that will be the phase out of coal in the Netherlands and also the rollback of renewable energy subsidies in Spain and Italy, in terms of saying, okay, those two areas fall within the purview of ESG, and what sort of accountability are we going to see, or attempts at accountability, really. I do think that it would be helpful if there was more guidance and also cooperation among among states in order to try to achieve these goals rather than leaving them solely up to companies. But I also recognize that a lot of countries right now are facing political landscapes that make that very difficult. And if you only have a political regime in place for however many years, and then it's another election season, and then who knows what's going to happen, and mainly we're just trying to fight immigrants or whatever the issue is, it's hard to keep your eye on the prize, especially because we also have, you know, the global economy to keep in mind. And I think that that's one of the sort of threats to ESG right now, is that ESG has gained so much momentum as part of the global conversation, but it's not free to implement. And if we are at a place where other needs, whether that's energy related needs or other economic needs, kind of come to the fore, that can make it so that companies and states are saying, yeah, no, we know that that's important, but like maybe we'll just come back around to that when we've gotten our interest rates together and maybe our energy prices are more stable or whatever the situation is. So I agree with you that there is a need for states to take a more leadership role in the conversation. And I think we could benefit from that, but I also am not feeling that they're necessarily well situated to do that at the moment.
Thank you. Any other question? Yes, more.
Highlighted the significant target because it starts to implemental goals, which means that we treat ESG in any steps from in one project format we may have a moving target, and as you we may have moving target, right? As the norms evolve, whereas with regard to environmental methodology, perhaps it is more stable in terms of how we perceive the operation goals.
Normally, these companies will be setting their own goals and trying to, if I take climate, there's an interesting initiative, which is the Science-Based Target Initiative, which sort of enables you as a company to sort of bulletproof your goals in terms of ambition, in terms of alignment with the Paris Agreement, because you never know whether, especially if you're an outsider, you know, somebody says minus 45, the other one says minus 30%, the other one says minus 6, you know, which is the best? Are they all, you know, where are they starting from? Whatever. So goal setting is basically a company responsibility, first of all, but then you need to stick to your goals. And this is where the practices have changed, because you basically you can no longer cheat more or less and move the goalposts along the line, because of disclosures, because of the fact that these are included in contracts, in financing contracts, in compensation. It really needs to be very square. It's not just somewhere at the end of a communication report. Okay, this is a huge difference. Then, because you're talking of targets, you need a reference year. For us, it's 2019, but you know, it can be different. I mean, that's not an issue. And another interesting aspect compared to finance, because you may, if you want to reach your climate goals, at least on scope 1 and 2 that you control, one way of doing it is just getting rid of your outsourcing everything, get rid of your manufacturing capacity and outsource everything, because your scope 1 and 2 emissions are just going to disappear overnight, and no offsetting and no more emissions. Just have the offices and maybe some cars and you're done. So the way the methodology works is you restate, which is very different from finance. You restate the baseline as you move along to make sure that whatever you do in terms of scope, like buying or selling companies, does not have impact on the trajectory on the target. So for us, like last year, we made a spin-off of all our chemical factories, So huge impact, not so much on CO2, huge impact on water withdrawal. But we restate. So we recalculate 2019 without those 6 factories, see what it looks like and see where we stand. And here you get surprises because one of those 6 factories was 80% of our water consumption. So it was the tree that was hiding the forest. And now we have all these little factories which all have basically what we used to say, you fix a leak in that factory and you're done for the year. You meet your target. And now we have to fix leaks in, 60 factories. Huge. But this is, calculation issues. I don't know if it answers your question in a sense.
So I'd say we actually agree that insofar as the main difference to me is that you can move your goalpost, but only to be more ambitious or aggressive. And so historically, there was a movement of the goalpost of being like, oh yeah, we'll get it done by 2020. And then it's 2019 and there's no way. And you're like, we'll make it by 2025. And then you keep moving it. Yeah.
Sorry for that. Was about the bottom line. We gave a great example about social expectations.
Mhm.
Minimum threshold right now is totally different than 20 years ago.
Right.
Whereas in climate, we still have the long-term goal of, let's say, 2030.
And my point is that you could take the same approach to both, right? So you could say that when we're talking about diversity, equity, and inclusion, that moves faster, but you still have goals within a company, and that company's goal might say, we want to have 1 woman on our board by 2025. Or you could say, we want our board to be half women by 2025. And the same thing could be said for climate, where you could say, we want to reach this goal that we think is like attainable by doing almost nothing, and we want to do it by 2025. Or you could say, we're going to set a more ambitious goal for ourselves, and we're going to push to be able to achieve it by 2025. There is more social pressure that changes, because I get your point that within the social constructs, there tends to be more social pressure that can move those goals in a more aggressive manner than perhaps there is with climate. But my point is mainly that within an organization, when you're thinking about those, you can be ambitious about your own goals in the same way, whether or not there's the social pressure of saying you could probably have more women on your board than that. You could take the same approach on climate and say, I don't need someone to tell me. I know that I could do more and that this company would benefit from that, rather than trying to do the bare minimum, check whatever boxes I can and then move along, say, what can we really do if we're going to push, if we're going to try to make what one of my clients called compliance plus, going above and beyond what compliance actually is. Was that helpful? Okay.
Any final question?
But it was about the states, so maybe you don't want this to be the last question. Yeah, okay, up to you. Now, with regard to states and how to put pressure on them to achieve their obligation, or I think human rights bodies can play a role here. I mean, you have recently the UN Human Rights Council, in a case involving Australia. You have pending cases before the European Court of Human Rights. So in terms of litigation, that's a venue to put pressure on states to meet their objectives. So that's one way. Another way, I think, is also the free trade agreements we referred to earlier. When you think about the labor chapters, the environment chapters, both in free trade agreements and also the provisions in bilateral investment treaties, this can be a template. And even if you think about the Nigeria-Morocco BIT and actually the obligation for states to comply with their human rights commitments, so that's kind of an enforcement mechanism for human rights obligations, that's also a template for the future. And it's interesting that states increasingly in their free trade agreements, they place upon themselves obligations with regard to human rights, with regard to labor, with regard to the environment, with regard to climate change. So that's also another path to put pressure on states.
I agree. That's exactly my point. But the issue is, of course, that it still remains to be resolved between them. And it is, of course, every state having a selective approach when and which issue it will raise with the other side, right? So that's kind of it remains like diplomatic protection in a way, right?
Yeah, but at the same time, if you take, for instance, the CAFTA, here trade unions have the possibility to kind of trigger the process. And this is what happened, and we ended up with an arbitration between Guatemala and the US. At the end of the day, it took years. But if you have such a mechanism which enables civil society to trigger the process, then we move away from this state.
Well, that's exactly
Discussion.
now I remember the name. It's the single entry point that the EU has introduced now as an I think it was actually to buy the ratification of the Netherlands for CETA, that they made this additional new element that but only European NGOs against European companies. So it's an internal thing, not with regard to Canada. That we have the single entry point where indeed NGOs, trade unions can come up as a amicus curiae. So I agree. But yeah, the question is, of course, we'll see how effective it is.
You also have the national contact points for the OECD guiding principles that are quite effective in a number of European countries, especially. It's a dispute resolution mechanism. It's not enforceable, but it has proven in a number of countries quite efficient, and it provides, I think, the necessary level of publicity for everybody to make sure that things get in line.
Yeah, naming and shaming works.
I'd also point to the fact that Germany has a new act on corporate due diligence and supply chains that essentially empowers NGOs and trade unions to bring claims on behalf of private claimants. And so to the extent that there is more empowerment through regulation for perhaps more sophisticated bodies to bring those sorts of claims on behalf of the private claimants, perhaps we'll see a little bit more movement in terms of those claims having a chance.
Then we had a question.
Yeah, sorry, maybe a final question, not specifically to any one of you, but when Nikos mentioned the Urgenda case against the state, do you see a downside in the investment arbitrations that ensued from measures taken by the state? So the Dutch state is now also, as you are probably aware, sued by German companies for taking measures in relation to climate change. So would that demotivate states, or do we think that states should just pay compensation when taking these measures? Sorry.
I don't have a position on this.
I don't know if I have an official opinion on this, but my thought is that I am not particularly concerned about it being demotivating. I think that states and companies have to live with a certain level of risk in the decisions that they make and balance that, just like you have to balance climate goals against the economy, against, the concerns of your population. It's always considering the potential impacts that come from any choice. Whether you're going to sanction Russia comes with its own fallout. So from my perspective, it is not enough to say that it's it's so demotivating or quelling that it doesn't still have its own value as a business.
No, I agree. Yeah. Thank you.
Thank you, Nikos. I think we come to the end of this discussion. It was a real pleasure to moderate this panel with you. And ladies and gentlemen, before we turn perhaps to the cocktail, and let's thank Gillian and Laurent for their participation and their contribution to this event.
But before we close, two things. First is brought you present as a thank you I'm not going to make the claim that this is ESG proof, otherwise you might sue me. But it is a unique present. You can open it. Everybody has the same one. Thank you very much. I think it was really a very, very interesting and really stunning, well, lecture, debate, our dialogue, I would say. And maybe, I think, because Miriam is now here, I don't know if you want to say a few words as I said, the chairwoman of the executive board of EFILA. So maybe you want to round up a little bit. You can hide that, but...
Very official introduction suddenly. No, just a few words. I missed your introduction, Nikos, because I came by car. I'm almost afraid to say it, and the traffic was, yeah, let's keep it. So if I say things that Nikos already said, then I'm sorry, but I wanted to thank you. I thought it was very interesting, very lively. I mean, to be honest, every other conference we can go to these days is in relation to ESG. I thought you made a very nice point of the broader meaning, basically. So we are all focusing on E, but let's not forget the rest. And I thought it was very interesting to get your practical view, and that is something. Well, I'm a dispute lawyer as well, that we often miss, of course, in these types of discussions. So thank you very much, and I think thanks to everyone for a lively discussion, lots of questions. I think I have to remind everyone to our conference in March, 16 March in Madrid. Jose Angel promised me that the weather in March is already quite nice, so I would hope to see everyone there, and well, let's go for the drinks.
Yes, now it's. Before you leave, let's make a picture. Oh, that's okay. Yeah, you can stand maybe just for. That's not so tall. Yeah, that's all right. Yeah, Jose, what?